In the previous video, we show the extent of the legal games that Doc Jamieson had to go through in order to win the right to sue the Chiropractors Board of Australia for the blatant defamation they enacted on behalf of race in Queensland in the form of a false statement that was posted online on the 17th of April in 2007, 2 weeks before the handing down of the court's decision and the not guilty verdict, in a case where the then Chiropractors Board of Queensland attempted to sue Doc Jamieson for the use of the word chiropractor in advertising his animal chiropractic services, which, as it turned out, he has every legal right to do. The first two videos on this story can be viewed on our website, phoenixtaskforce.org, and on the Phoenix Task Force YouTube channel. In this video, we're going to break down the bombardment of further legal games that ensued to delay Doc's compensation after finally winning the right to sue the Chiropractors Board of Australia for defamation. To quickly recap, Doc was first warned in 2003 about the use of the title chiropractor in his advertising, being told by the Chiropractors Board of Queensland that they recognised him as an animal chiropractor and that his advertising must be in clear reference to animals. Then, in 2005, the board initiated legal proceedings to prosecute Doc for the use of the chiropractor title, which they lost after having already given him the okay to do so. But 2 weeks before the not guilty verdict was declared, the board posted a public statement on the Office of Health Practitioner Registration's board website, thoroughly defaming Doc's good name by stating that he'd lost the case, that Doc had refused all attempts at communication by the board to resolve the issue amicably, and that Doc was entirely responsible for the matter having proceeded to court. But the complete opposite was true, and it was eventually ruled in court that the board must compensate Doc for the unprecedented damages they had caused to his name, business and reputation. However, this was not before the false statement had remained online for 19 months, or before Doc was misled by his legal representation in their incorrect advice regarding the statute of limitations to sue for defamation, resulting in the dismissal of an unnecessary application for an extension of limitation period that hadn't even expired yet, and which was finally overruled 2.5 years after Doc discovered the false statement, and a total of 4 years after Doc had already won the case against the board. All of this was instigated by Kerry Watson of the board of the Greyhound Racing Authority, who leveraged her connections in the Chiropractors Board of Queensland to attack Doc, as well as instigating the GRA's false inquiries against Doc at the same time. On top of this was the non-stop harassment and intimidation Doc had to face all the way through, altogether amounting to one of the most shocking and unique journeys of adversity that any human being has ever had to survive, all for the sake of standing in the name of truth and integrity. But this monstrous denial of natural justice didn't end here, and you won't believe the legal games that continued to ensue after Doc had won the right to sue the board for damages. After the final hearing of the appeal to overturn the dismissal of Doc's application to extend the limitation period, this was in October of 2010, the final decision wasn't handed down until 5.5 months later in March the following year. The solicitor Doc had hired for the final hearing, Paul Donnelly, was notified of the handing down, but he never told Doc, so not being able to attend, Doc not only lost the respect of the courts and missed the opportunity to have the media canvass his success in helping to restore his good name, but also lost the opportunity to submit for thousands of dollars in costs. As a result, a cost assessor was ordered, causing even further delays that would have otherwise been unnecessary if only Doc was able to attend the handing down. Since the final hearing 5.5 months prior, Doc hadn't actually heard from Paul Donnelly or Carlton Thomas, the con man who was hanging around during the appeal hoping to get a free payday, and who recommended Donnelly to act as Doc's solicitor on the day of the hearing. Doc continued to try to reach Donnelly, but never heard anything back. Doc had to file notice that he was no longer represented by Donnelly and wrote to the courts to explain himself for such an embarrassing situation. In May, Doc filed an initial cost statement for just over $44,000, which after finalising came to almost $48,000. But the board objected to almost $42,000 of those costs, reducing their proposed compensation amount to a mere $5,796. Now remember, this is just for the matter of court costs at this stage. We haven't even gotten into the matter of damages yet, and clearly the board were not going to allow this process to unfold without strong antagonism. Then came the appointing of the first cost assessor, Michael Graham. Doc didn't really have any say in the matter and was forced to agree to the appointing of a court-approved cost assessor in order to be able to receive compensation. A month later, Doc provided the board's solicitor with a revised cost statement to the amount of around $41,500, a reduction of $2,500 from his original cost statement. Doc made this reduction despite his financial situation, which was growing progressively worse, having had no repair to his reputation, continuing to pay off administration fees from having brought the matter to appeal in the first place, having to sell furniture in order to survive, and no longer being able to afford his own residence. By now, the cost assessor had been sitting on Doc's file for more than 4 months, and Doc was still yet to receive the initial cost payment of $1,700 ordered by the court some 9 months ago. After yet another month had passed, still without any word from the cost assessor, at which point Doc had already began filing further submission to the courts to show what was basically a communications blackout from the cost assessor and try to prompt the matter to be resolved as soon as possible. Then, after a full 9 months had passed, with still zero communication from the cost assessor to either Doc or the board solicitor, Doc wrote to the courts for advice. By now, Doc was completely and utterly financially wrecked. He'd lost everything in the Queensland flood disaster of 2011, he was homeless and still having to pay $800 a week just to board his greyhounds, and he was incredibly sick from having nowhere else to live except inside his dog trailer. A week later, the courts replied to Doc advising him to arrange for a new cost assessor, and so Doc had to continue to outlay administration fees to make this happen. But the months dragged on as Doc's situation continued to worsen, until finally a second cost assessor, Stephen Hartwell, was appointed after almost a year of complete inactivity by the first cost assessor, with the only action taken by him being to return Doc's file after the job was taken off him. But why did it take the better part of a year for Michael Graham to do absolutely nothing? What kind of high-profile cost assessor in their right mind would sit on a job for 11 months and not do anything with it? With all of the drama, delays, getting the runaround, harassment and legal games that had now been going on for the better part of 7 years since the start of the case against the Chiropractors Board in 2005, undoubtedly this was all part of the ploy to crush Doc Jamison's resolve and destroy his life. And the games continued. In the same month he was appointed, Stephen Hartwell notified Doc via email and over the phone that he was withdrawing from the appointment. For whatever reason, Stephen suddenly didn't want anything to do with the case anymore, and Doc was left again to arrange yet another court-approved cost assessor, and a third appointment was drafted. Somehow it seemed that the board's counsel were not aware that Hartwell was withdrawing until 2 months later, and just as soon as they'd asked him why he couldn't do the job, suddenly he's not withdrawing, blaming the confusion on an ambiguous mix-up in his office. Obviously, Doc wasn't comfortable going ahead with the cost assessor who was changing his mind at the drop of a hat, as well as having already outlaid for a third cost assessor, so he raised it with the courts and reached out to QPILCH for advice. But in the end, he was forced to go ahead with Hartwell. Doc apologised for the muck around to the third cost assessor, who was probably thanking his lucky stars that he didn't have to get mixed up in all this drama. He tried to get Hartwell to come clean on what the story was behind his indecisiveness, but Hartwell just kept his head down and got to work. Then, after barely a month had passed, Hartwell was finished with his assessment and sending Doc the bill, which Doc had to work extremely hard to pay. But in an unexpected turn of events, showing up in the items of the cost assessment, trying to get their hands on more than $30,000 of the settlement of Doc's costs, was the trustee for a sequestration order in the bankruptcy of Paul Donnelly, Doc's solicitor for a day during the final hearing of the appeal. It turned out that as early as July of 2012, this trustee had completely bypassed Doc and gone straight to the Chiropractors Board Council to chase payment for what were unpaid legal fees that Doc supposedly still owed to Donnelly, with a memo surfacing that was allegedly sent to the board's counsel a year before that, just 2 months after Doc had won the right to sue. And before Doc had even had a chance to comment on the matter, it was already being added and worked into the cost assessment. It wasn't until the middle of October when Doc was finally made aware of this issue. Doc, of course, told the board's counsel that Donnelly was full of it, and afterwards Doc continued to remain in the dark about what was going on between the board's counsel and the trustee. Once again, the board rejected the cost assessment thanks to the drama caused by the timely insertion of the matter of Paul Donnelly's bankruptcy antics. And after all the muck around, all Doc could claim for with regards to Donnelly was a paltry $1,000, despite that Donnelly had cost him many thousands more than that. Games, games, games. How on earth Doc had managed to survive this far is testament to the man's integrity and resolve, but the cost to Doc up until this point was incredibly high. He had to wait 2 weeks after paying the cost assessor before he could even view the certificate, which had been completed more than 2 months before that. He'd missed out on up to $6,000 in costs from not having been notified of or being able to attend the handing down. He was now out of pocket more than $45,000 and still owed many thousands more, and on top of being homeless and sick from living in his dog trailer, he'd developed a severe leg ulcer from the stress of an ordeal that had been ongoing since 2005. Finally, on the 18th of December, the cost assessor's certificate was provided. The final amount ordered by the court on the same date was $15,562.20 that was to be paid within 14 days, and Doc invoiced the board accordingly. But by the 4th of January, 17 days later, the board still hadn't paid. When Doc raised it with the board's counsel, they told him he still needed to provide the cost assessor's written reasons, and that they could still take up to another 14 days to review it after receiving it before they had to pay, and they still wanted further clarification on the issue of Paul Donnelly. So, over the next 4 days, Doc managed to get Hartwell to cough up the written reasons document, submitted it to the courts, provided it to the board's counsel, sent them the proof that Paul Donnelly was full of it, and then guess what happened? The board waited out the 2 weeks and objected. The matter went back into the courts, and it took a further 2 months before finally the court ordered costs to be paid for an amount the Chiropractors Board was finally happy with Doc flipping the bill for the cost assessor. Then after another month and a half, the board finally paid Doc, in contrast to Doc's original cost statement of over $44,000 and with the whole ordeal costing him immensely more, a measly $7,500. How's that for justice? Believe it or not, the story only gets worse from here. All the way back in 2011, after Doc had won the right to sue, Doc enlisted a forensic accountant by the name of Stephen Ponsonby of Forensic Accounting Queensland to calculate Doc's damages. At the end of 2013, some 7 months after Doc was paid a drop in the bucket for his costs, Ponsonby's initial report was ready and provided to the board's counsel. It took the board a further 4 months to finish mulling it over before a date for a settlement conference was set, which was the 28th of March the next year in 2014. Before attending the conference, Doc sought the only legal advice he could, that of the volunteer lawyers of QPILCH, the Queensland Public Interest Law Clearinghouse known today as Law Right.
We're volunteer solicitors.
Yes. I know that.
It helps out
the
service. We're not experts in defamation.
Yes. Some of the questions that I wanted to ask you guys about the conference with the settlement. And the hard part is that I haven't got a solicitor because I haven't got one that will act for me in Queensland, which is pretty pathetic. At the self-represent.
Is it a conference or a mediation?
Conference for settlement.
What happens at a settlement conference? It's what they call without prejudice conference, which means no one can rely on anything that's said in that conference. Whatever you say in there, it can't be used later on. Whatever they say equally can't be used later on. So if they offer you a certain amount of money, you can't later on say, well, you said this, you offered me this much, why are you now refusing to offer anything? You can't use any of it in evidence before the court. I mean, honestly, a lot of time what people say probably doesn't make a lot of difference, but you should be prepared to make the most important points and the strongest points for your case.
Well, they wrecked me life, my business and everything.
That's...
I got all the proof of that.
Shut down 3 clinics.
4 clinics it was.
Lost property.
You know, my vehicle's a whole lot. I've had to just move again because I had no money, so I've been booted out where I was. When's it going to end? I just want to settle. I want to move on in life. I'm tired, you've taken everything off me. Should I have a solicitor or someone with me for that day as well?
Generally, that's a good idea for something like this.
So would you be better just going straight to court? Because, I'm sick of the game. I'd rather have a jury. I was in the right. I've done nothing wrong and I've lost everything. When I paid the court costs, it cost me $44,000. So I got $7,500 back. Then I had to put in the cost assessors. They hit me $3,000 for that as well. The board just kept arguing. They're games. There should be a royal commission in the legal system and clean it up. It's not for someone who's self-representing or someone who's honest. And I know when I went in to fight the board, I never went in there for justice because there's no such thing as justice in the courts. I went in there for error in law, and that's how I beat them, with the error. I've laid it in the hands of the courts before and got nowhere.
You did have some wins.
It had nothing to do with solicitors, but I lost my solicitor, Peter Boyce, worked in with the Chiro board. That's what's made me better with the solicitors and that in Queensland. All this is set up to wreck me. I have the evidence, 100% concrete with witnesses a lot. It's not the normal run of the mill what's going on here, guys. That's the difference. It's been a hard road and I've had over 13 dogs poisoned. I've had my cat poisoned. I've had my equipment wrecked. On the way here, I got followed tonight. Why are they still intimidating me? Got to have protection. Stupid. Nothing's been done about it. A lot of animals are dying because I can't get out there working because I've got to be in behind closed doors by dark. I've got cameras right through my house. My vehicles, everything, it's crazy. Cutting the fence, wrecking me equipment, undone all my gas, all this. Attorney General and Crimes Commission, the whole lot of them's got it and done nothing.
Yeah.
Where's the law?
Have you spoken to the police about it?
Police won't do nothing. Too high for them. I'd go to the cops and the cops didn't want to touch it because it's too big. You know, when you get detectives and that saying, oh, this is over our head, it's too corrupt up their head. I don't want to hear that. I want to hear that there's a fair system, you know. The police prosecutor said go and have criminal charges laid on criminal defamation. Maybe it does have to go criminal because there has been colluding, there's been corruption, there's been everything involved in it. First, when they took me to court and I had a jail sentence and a fine over my head, so I won the case, right? And then before I walked out the court, the statement was up on the internet, on their website and all the universities saying that I was found guilty and charged by the courts. So if you Google animal chiropractor, that come up. I waited for 18 months. How come my business dropped off? It's because of the statement. Then a client found it, and I didn't believe it. Had to put it in my face to show me. After that, then I win the case, and then they still scroll me around thinking I'm going to go away. I'm not going away.
No, they should have realised that.
Yeah, well now they have, yeah.
Unfortunately, it was not the most inspiring or helpful advice. So the moment Doc had been working towards for the past 5.5 years was getting very close. Too close, it seemed, for the board, and certainly for Racing Queensland. They had successfully destroyed Doc's life up to now, and the prospect of a settlement meant the threat that Doc could get back on his feet financially and focus again on exposing the cover-ups and corruption of not only the greyhound racing industry, but also, after the almost 6-year ordeal he'd just been through, the corruption of the legal system and the orchestration of the denial of natural justice. 3 days before the settlement conference, Doc was assaulted, knocked unconscious and hospitalised, forcing him to delay attending the conference. And this is just one of the instances in which Doc has been assaulted in the same way, and always timed right before key events in which Doc would otherwise gain the upper hand in his fight against corruption. The conference was rescheduled for the following month, and after being advised by QPILCH that he should have a solicitor present, Doc agreed for Ponsonby to arrange for a solicitor he knew by the name of Patrick McCafferty. They met up before the conference, and Doc handed over 3 more folders of evidence, including internet logs from the board's website showing almost 700 hits on the false statement during the time that it was posted online, which Michael Lucy, a lawyer from the firm representing the board, provided to Doc back in 2011 by order of the courts. This would have pushed the actual amount for damages into the multiple millions of dollars. Patrick turned out to be a mistake because, like just about every other solicitor who's ever represented Doc, except for John Walsh, Patrick wasn't supportive at all, and he may as well have been representing the other side. Ponsonby was equally useless during the mediation because when Doc contested the board's counsel claiming only 12 website hits on the false statement webpage, Doc referred to Ponsonby to show the board's own internet logs proving 700 hits, but Ponsonby said he couldn't speak on it, and Patrick didn't speak up either.
The problem is we sort of come here today with a view to trying to settle this.
Yeah.
What's your expectation?
Well, I don't know really, Patrick. That's why I was sort of asking you. This is 10 years out of my life.
My own view, I think the general damages part of this case is probably worth about between 30 and 50 grand. Anything before 2007 is irrelevant.
I think we should just go to court and I'll pull everything out. You know, let's get a jury and let them go for it. I've had dogs poisoned, I've had temps on my life, I've had stuff damaged. Is that correct?
Yes.
I've got videos, I've got recordings of the whole lot. I can prove the intent to damage. This shouldn't be civil. This should be criminal defamation.
You're not the first person that's come to me and I give an advice to, okay? You're probably about the 400th. I've seen litigation ruin people before, all right? Happens every fucking day. I'm just generally telling you what these cases do, and you will not find a defamation case in Queensland which has given someone more than 112 grand.
Oh, well, let's go to court. I don't even want to sit here today. Let's go to court.
You will not get more than 50 grand out of these guys.
Well, they offered me 50 before. Well, how about we just end it here now and we go to court?
Right.
Okay, I think that's what we do. Go to court. I'm going to bring out all the corruption, the videos.
Are you prepared to run the case yourself?
Well, if I have to, I have to. I've got no choice, eh? Because all I've done is outlaid, moved, lost everything. I've had 16 animals poisoned. I've had attempts on life. I've got proof of the whole lot. I've got videos everywhere. This should be criminal defamation. I don't even know what we're here for today, guys. I really don't.
Well, someone's asked me to come to a settlement.
Yeah, well, I
think it's worthwhile. It'll be a waste of time at the same time. Paul, I'm going to leave you out of it only because you're not connected in that sense to the proceedings. I want you to take a note. But the three of us are going to go in that room if you're comfortable. their lawyer just wants to say about 5 things to you and their position, formally make an offer to you, which I suspect you'll reject anyway, and then we can just call it a day.
Yeah, all
okay?
right. Yeah.
So is that okay, Paul? No
Yeah,
offence to you.
as long as Doc can get a copy of the notes or what
Yeah, well,
was
stop.
said.
That's why Steve's coming to me.
Okay.
You come in to take notes.
So all this whole conference is without prejudice, so anything said today can't be used against any of the parties. That way we can speak freely.
Yeah, I understand.
Good man. Now, what the court will take into account in awarding your general damages is the seriousness of the publication, how long it was published, how widely it was distributed. Now, we know it's on the Health Practitioners Regulation Board's website for over a year. The best that the board's been able to determine is it was viewed by 12 people over
700. I got it from the courts. They gave me a letter back saying they handed over 700 hits. The chiropractor board sent me the hits on it and they said 700 hits. I went to court and got a court order to get them to hand over the hits. And they weren't going to do it. They played to the end. And then they handed over 700 hits. And this went to all the universities all over. It's done a lot of damage to me. And there's 700 hits.
Well,
there was more than that, but they handed over 700.
We haven't heard that at all.
No, well, I got that. I got it all.
See, when
You should have that, Steve. I sent that through.
I'm not here to comment.
Okay, yeah, sorry. Yeah, 700 hits.
I'm going to be fair today, Steve, and not go into details about your report because you're not here to respond to them. I don't think that would be fair for me to do. But let me just say, in my opinion, there's a number of fundamental errors in the report. We don't accept the calculations that are in the report. The board hasn't at this stage gone and got its own forensic accounting report. The board's of the opinion that any loss, anything that you've suffered so far as financially, they don't agree you're able to demonstrate any of that. But even if you have, we're of the opinion that it's largely come about by the fact that you keep reproducing this statement on your own website.
You forced me to do that. You forced me to clear my name.
For the purposes of not finishing our side of it today, the previous offer from the board was $25,000 for this case. So in order to avoid the cost of the trial, the board is prepared to make you that offer today, $50,000 plus costs.
You know how much I've lost? My appeal thing was $44,000. And I got back 7,500.
That's our position, John.
Yeah, it's wrong.
If the matter doesn't resolve today,
It's wrong.
Then the next step, in fact, in the matter is litigation. It is a trial that was exhausted all over other avenues. So
that's right. They've dragged me to the limits. I've tried to solve this so many times, and they just want to drag me out to them. No, but I'll never lie to them.
Right. Well, there's our position, John.
Yeah.
$50,000 plus.
What a joke.
Plus your assessed costs.
Yeah, what a joke.
You wanted $44,000 for your appeal costs. That was your expectation.
That's just what me outlay.
That was your expectation.
Me outlay.
And you got 7.
Yeah.
Here, you want an astronomical amount of money, and we're offering you 50.
You know what I've lost? I've lost. Doesn't matter. You don't care anyway. All right. I think revenge, you say? Yeah, because this is just a joke. This is a joke, Michael. Yeah, Steve, Doc, mate, how you going?
Good. I can't really talk tonight. I'm actually in a meeting.
Oh, all right. I just couldn't understand why you weren't allowed to talk yesterday in the meeting, mate, or hand my documents over with the hits.
That was explained by the barrister. I was there purely just to take the minutes. I'm not there. I can't talk at the moment. I'll have to ring you back.
All right, no worries.
Cheers.
So what was the point of having Ponsonby there in the first place if he wouldn't speak on the evidence in support of Doc? Isn't that what Doc was paying him for? What reason could he possibly have had for not speaking in a settlement conference that was supposedly without prejudice? According to Ponsonby, he was only there to take notes, which were never provided to Doc. Afterwards, Doc tried to raise the matter of what happened in the settlement with the Legal Services Commission.
Good morning, Legal Services Commission. Sarah speaking.
Yes, Sarah, it's John Jamieson here. How are you?
Good, thank you.
Hey, is there someone I could have a quick word to? I was having a mediation with the Chiropractor Board of Australia. Yes, it's supposed to be a settlement. I had my forensic accountant there, and in the meeting, they wouldn't let my forensic accountant talk. It's a little bit strange to me that my forensic accountant's cost me a lot of money to get all my stuff put together, and They wouldn't even let him talk when I've asked for documents. My forensic accountant had documents, never produced them because he wasn't allowed to talk. This is what my barrister said, you can come in to the meeting but the forensic accountant's not allowed to talk. What's the use of that? I'm arguing a point saying, they say there was 12 hits, this is about defamation, 12 hits on the internet. They released, their Chiropractor Board Australia released me 700 hits. My forensic accountant had it in his bag. My barrister's there, listened to everything, didn't say a word. And I turned to my forensic accountant and said, well, you know, you've got the hits. And he said, I'm not allowed to talk.
It sounds like it's the forensic accountant, and we don't have jurisdiction over them. You can certainly lodge a complaint, but it's going to take 28 days to review and assess the complaint, and then there's no time frame from there.
All right, I'll lodge a complaint.
No problems at all.
All right.
Okay, bye.
Well, that wasn't very helpful. With Just Doc's documented damages stretching well over $1 million and not even counting the 700 hits on the false statement that would have pushed that figure much higher, the board's offer of $50,000 was an insult. But being fed up with the years of legal games, Doc just wanted to see an end to the drama, so he counter-offered for a settlement amount of $100,000 and a written apology signed by every member of the board, just enough money to pay off his loans and get out of debt, and an apology to help in restoring his name and reputation, but nothing to even scratch the surface of the years of damages he's sustained. The board, however, never responded on this, and the matter persisted, ending up back in the courts again, continuing to remain unresolved for a number of years afterwards, and eventually culminating in the escalation of some of the most atrocious harassment that Doc has ever had to survive. More on this in the coming video. So the last time Doc had ever spoken to Ponsonby was the day after the settlement conference in 2014. Then, 2.5 years later, out of the blue, Doc was served with a court summons after Ponsonby had claimed for unpaid fees of over $20,000. This was after Doc had already paid him some $30,000. After a very brief phone call between Doc and Ponsonby's counsel where no terms were agreed upon, Doc took an offensive position serving legal documents on both Ponsonby and his counsel, having also filed the same into the courts. This turned out to be a very powerful move as the matter was instantly silenced with the court summons on Doc never being enforced. 1 year later, there was a brief murmuration from Ponsonby, but again Doc fired back with a potent letter of reply reminding Ponsonby of every ounce of truth that Doc had in his arsenal and requesting a full accounting of all correspondence and documentation that was handled by Ponsonby in regards to Doc's case. And then Ponsonby was never heard from again. How many other people are out there being denied natural justice and being crushed by the corruption of the greyhound racing industry, the legal system and the regulatory bodies that are supposed to be looking after the welfare of the public? Let us know if you've been witness or victim to the same kind of harassment as Doc. Remember to sign the petition and show your support towards cleaning up the greyhound racing industry. And sit tight for the next Doc versus the Chiropractors Board video where we'll go into how Doc survived the monstrous harassment that was orchestrated in attempting to prevent Doc from successfully suing the board for the unprecedented damages he sustained and attaining natural justice.